We spent a lot of time together. I think we are growing old together. I say that this is an important case, and I don't think that's lost on any of you here today. I don't think it's been lost on you in the month that we have spent together. It's kind of the moment where I know Mr. Dean pointed out that we get an opportunity to go first and last, and they only get an opportunity to go once. But sometimes it's kind of a two-edged sword, because kind of when we get to this moment, sometimes I stand up here and I kind of get the sense that you want the lawyers to shut up and sit down and let's get to work. And I get that. So like I said, it's a little bit of a two-edged sword, but I hope that I appreciate the opportunity to be able to respond to some of the things that defense counsel argue, and I don't want anybody to think that any of the responses that I give to Mr. Dean's arguments are meant to be disparaging in any way. And one of the things that we learn as lawyers, kind of because we are in a courtroom, and this is a very adversarial process, we learn very early not to take things personal. And so I don't want anybody to get the impression that anything that I say would be disparaging of any of the arguments that he's made. Just as I want you to listen to the arguments that I make, you should listen to the arguments that he made. But that doesn't mean that I agree with them. And I'll tell you flat out that my arguments, that a lot of the arguments that he made to you, I believe are flat wrong. And I'll explain some of those to you here as we kind of continue to talk. One of the first arguments that he made to you was that the state has sort of paraded around the knife as though it's this important piece of evidence, and you know, it's one of those things. It's a big knife. It's a very menacing looking knife, and somehow, and the defense argues that this has nothing to do with anything. And he pointed out our question when I was up here before, when I asked why did the defendant throw it out of his car, and did not answer the question. Well, and he also stated that I made a comment that it had no evidentiary value. I did not say anything of the sort. And you can rely on your own memory on that. But the reason that the knife has evidentiary value is not because we believe, and of course what we believe is not evidence, it's what you're the jurors, you determine what is the evidence. You're the ones that draw the conclusions in this case, and it's up to you to decide how important the knife is, what evidentiary value it is. But I submit to you that the reason that it has evidentiary value is because the defendant threw it out for a reason. And I submit to you that the reason that he threw it out is because he had a guilty conscience. These crimes had been committed. He had committed a crime. Other crimes that he claims that he did not commit, but he admits that he did commit some of those crimes. And here he is, he pulls up into his neighborhood and he sees the police, and what does he do? He throws this knife out the window. It is true. I'll admit to you, we have no idea whether or not the knife has anything to do with a crime. We do know that the bodies were disposed of, and because of that, because those bodies were disposed of, we will never know how Yesenia Suarez, Leah Otto, and Michael Otto died. We don't know that because that evidence was disposed of. That evidence was not available to us. So we don't know. Now, that doesn't mean that the defendant is not guilty of these crimes. It doesn't mean that the victims aren't dead. I think I went through all of the evidence with you very clearly to show that we have proven beyond a reasonable doubt all of those things. So you will decide what evidentiary value that knife has. I submit to you that the reason that it has value is because him throwing that knife out the window meant that he had a guilty conscience, and he had a guilty conscience for a reason. And everything that you see, everything that you heard from his own statement, cleaning the house, disposing of the items in the dumpster, getting rid of Yesenia's car, all of those items, again, as I said before, those are not the actions of an innocent man. Those are the actions of a guilty man. And it's your job as a juror to evaluate that evidence. And I submit to you that, and this is what you do in a criminal case. This is not this place where you come and something magical happens. common sense applies here. When the judge reads you the instructions about reasonable doubt, the word reasonable is used for a reason. It's not all doubt. It's not every doubt. It's not beyond a shadow of a doubt, as we talked about in jury selection. It's not a speculative doubt. It's not a forced doubt. It's a reasonable doubt. It's what makes sense. What makes sense? We're not living in a world where you put your common sense, you leave it at the door. When you come in here, you bring that common sense with you. And that's what we're asking you to do in this particular case. When you look at the circumstances of this event, the defendant gave a statement. We were asked, what evidence do we have that proves our case? Well, much of that is the defendant's own statements. Now, we know that from the circumstances of this case, only two people could have killed Michael and Toledo, and that was either the defendant or Tyshawn Jackson. And I went through during my first closing argument, and I pointed out to you why you cannot trust the defendant's statement. Because he lied over and over and over again. He told a story, and he couldn't keep that story together. His details changed one after the other. And because of that, you can believe, you can draw the conclusions for yourself that his statement, to the extent that he is absolving himself of the murders of Michael and Toledo, you don't have to trust that. And I submit you should not trust that. And the other reason is because he is the only one in this case with motive. You know, I think we were chided just a little bit about how we spent day after day after day about the marital problems that Luis Toledo, the defendant in this case, had with his wife, as if somehow that wasn't important. It's vitally important. The reason that we spent the time doing that is because we knew at the end of the day, the argument would be that we didn't do enough. And so we spent the time, we took the time to present each piece of that evidence because it was important. Why is it important? Because the defendant is charged with second-degree murder, and one of those elements is that he killed Yesenia Suarez out of ill will, hatred, spite, or evil intent. Those problems that they had in their marriage, whether it was because of Luis Toledo and what he was doing and what he wasn't doing, whether it was because of Yesenia Suarez and what she was doing or what she wasn't doing. The fact of the matter is they had problems, and he was very angry about those problems. She cheated on him. He confronted her, and he didn't do it in, he did it in a very angry fashion. Over and over again. Goes to her job. That's important. That's important evidence. Because you can see through those text messages that his ill will and his hatred are building and building and building until it culminates into this act that occurs in the early morning hours of October the 23rd of 2013. The defense also said that the arguments that we were making regarding the killing of Yesenia Suarez was if we were arguing that that was first-degree murder, and that's not the case either. I don't know that Luis Toledo intended to kill Yesenia Suarez. That would be first-degree murder. I submit to you that he's not charged with first-degree murder. He's charged with second-degree murder. And the judge will read you an instruction that says the state does not have to prove that the defendant had the intent to kill Yesenia Suarez, but that he killed her and that was motivated by ill will, hatred, spite, or evil intent. Now, he also talked to you a little bit about the interview on October the 23rd of 2013. And he played you a portion of that video. And he did that in response to our argument that on October the 23rd, actually the interview he played you was on October the 24th. And he did that because we argued to you that on October the 23rd, obviously his story was, I don't know where they're at. All I know is I got upset, I left, I came home, I slept in the driveway, I get up in the morning and they're gone. And he stuck to that story. And at the end of that interview, he's confronted with evidence that the defendant has to know only could have come from Tyshawn Jackson. And it wasn't until the next morning that his story changed. And the reason his story changed is because he knew he had to come up with something very quickly. And he played the video that shows the defendant as he begins to change his story and admit that he killed his wife, that he was sobbing. Well, think about that for a minute. As if somehow the fact that he appears to be emotional in this interview is somehow evidence of his credibility. He killed his wife and his children. There is plenty of motivation to put on that performance. And so the fact that he is sobbing, the fact that he is crying, is not evidence, any special evidence of his credibility. They also take issue with the timeline, that somehow the defendant could not have, within those 4.5 hours, could not have done this by himself. Again, never underestimate the ambition of a person who has committed murder of his wife and 2 innocent children. What is interesting is that the defendant's own version of events is even less plausible and less, in fact, it is impossible. The defendant's story was that none of this event even began until 3 o'clock in the morning. He says, I left at 1. I came back at 3, and I see Tyshawn Jackson. He gives several different versions of what Tyshawn was doing, more inconsistencies as we talked about earlier. And then he invites Tyshawn Jackson into his house. Again, we talked about how that makes absolutely no sense, that Tyshawn would accept an invitation to come into his home, and not only into his home, but into his bedroom where his wife is sleeping at 3 o'clock in the morning to play video games. But that's what the defendant's story was. All of that started at 3 o'clock. Then that was just when he saw Tyshawn. So he has to come into the house, go into the bedroom, wake up his wife, then they have an argument. He kills his wife, the kids come out, takes them into the bathroom, kills the kids, and that's when, however long that would have taken, that's when the cleanup begins. And Tyshawn takes the kids, the bodies of the victims. And what was it the defendant said in his interview? Now, get this. Now, at 3 o'clock is when all of this started. And the defendant's story is that when Tyshawn Jackson left, he was gone for 2 hours. 2 hours. He comes back and he does another trip, and that takes about an hour and a half. And according to the defendant's story, he's at home. He's cleaning. He's cleaning. He's cleaning. He doesn't know where Tyshawn goes. He doesn't know where the bodies are. The problem is that the defendant's own flesh and blood brother, contrary to what the defendant said, his own flesh and blood brother said that he was at his house alone at between 5 and 5:30. So the defendant's own version is impossible. His own version puts him at the house cleaning. Remember, Tyshawn's gone for 2 hours. If it happened exactly at 3 o'clock, that means Tyshawn is not even getting back from the first trip until 5 o'clock. And then he's gone for another hour and a half. There's no way that Luis Toledo could be at his brother's house between 5 and 5:30 if he's at home cleaning. So this idea that somehow our timeline doesn't make sense, the defendant's timeline makes no sense at all. It is impossible. He had 4 hours. 4 hours to take those bodies wherever he took them. Didn't necessarily have to go a long distance. Nobody knows. Yeah, they searched and searched. They weren't able to search everywhere. Who knows? 4 hours is plenty of time to do all the things. And he was still, after he had picked up Tyshawn and they had dumped the car and he took Tyshawn and he dropped them off at the 7-Eleven, he was still getting rid of evidence. He went back home and realized, hey, there's more stuff. And so he puts it back in his car, a rainbow vacuum cleaner. He has the stuffed animals, and he takes them over, and he dumps them in the other dumpster. He's still getting rid of evidence. They also made the argument that the defendant, that the statements, I believe that the way that defense described them was that the two most important pieces of evidence in this particular case concerning the defendant's sort of admissions that he committed these crimes, one of which was his statement to Tyshawn Jackson that he snapped. And I think the argument was that that's not evidence of premeditation. Well, it's interesting because in the interview on October the 23rd, he actually used that same term. I don't know. I actually had to go back and look at the transcript because I missed it. But on the interview on October the 23rd, he was talking about how his story at that point was, I came home and I slept in the driveway and I got up the next morning and my wife and kids were gone. And in that interview, he's upset about that. He was upset that his wife got loaded up the kids, which in and of itself is sort of implausible when you think about it. When loading up two young children, and you open the garage, and he's right there in the driveway, and somehow with all that commotion, he's not awakened. But of course he changed that story. So he admitted that was a lie later. But when he described that story and his feeling about how he felt when she didn't wake him up, he said, "I'll snap on her ass that the kids are not in school." So these are words that he used in another context. And the argument was, that wasn't recorded. The same with the criticism of the statement that he made to Kurt Sheps there on October the 26th that Detective Ford overheard. And the argument basically was, it wasn't recorded. Well, it wasn't recorded because the defendant said, don't record it. Throw the recorder away. And somehow, basically what the argument is that the law enforcement officer lying, that they made it up, that he didn't really say that. Well, here's a question. If you're going to make something up, why not just say, he confessed to me. He said, I killed my wife and I killed my kids. If you're going to make something up, then make it a good one. Make it a good one. Why just stop it? I'll never tell you where the bodies are. He also brought up the fact that the argument was that it made no sense that when Tyshawn Jackson was with Luis Toledo and dumped the items in the dumpster, his description of the ride back was, it was quiet, that there was no talking, that he didn't want to ask him any questions, and somehow that just doesn't make any sense. Well, in the defendant's own interview on October the 24th, the defendant himself said that the ride was quiet. On page 53 of the transcript, whatever time that is on the video, he said the ride was just quiet. The defendant himself confirmed that information. There was an argument about the phone call from the jail. And the question was, what does that prove? And it goes back to the argument that I was making earlier about this turmoil relationship between the defendant and his wife. What does that prove? Again, it goes to his state of mind. It goes to the hatred, the ill will, the spite, the evil intent, the things that he's reflecting on that event in his life. Yeah, it was a year and a half later, but he's reflecting on how he felt at the time. And the language that he used, he spent that almost entire 40-minute phone call trashing her up one way and down the other. Why is it important? What does it prove? It proves his ill will, hatred, spite, evil intent toward Yesenia Suarez. The letter about the packages to Mexico. That question was asked, what does that prove? Well, it's interesting, is it not? It's not a confession. But it is interesting that the defendant in this letter, which was read, and it's this letter to, I believe, a person that went to the defendant's church, and there's all this nice letter, and then suddenly in the middle of this relatively pleasant letter is a paragraph in Spanish. And this paragraph talks about 3 boxes, 1 large and 2 small, that's sent, I believe it was to Laredo, Texas. And it makes you wonder. It makes you wonder, is this a joke? Is this somehow a joke? Is there a message here? It's for you to determine what that means. Honestly, I don't know what it means. But it is, when you consider the circumstances of this case, that his wife, an adult, is killed, and his 2 children are killed, and he writes a letter that references a large box and 2 small boxes that are being shipped to Laredo, Texas. It certainly makes you wonder if he thinks that this is some kind of game or joke. The defense also made the statement that motive is not relevant in this case. That's just flat wrong. Just flat wrong. Motive is not an element of the case, but motive is what tells the story. Motive is what motivates someone to commit a crime. It is what motivates them and their intent to commit a crime. And while we do not have to prove motive, that when we can show you motive, it is important. It is important because it tells you exactly why the defendant did what he did. And that's why we presented all of that evidence to you. At the end of the day, when you stop and consider this, and the defense asks, what evidence has the state presented to you that proves that the defendant committed these crimes? And somehow the argument is something, I believe the reference, the question to Detective Pagliari. And it's this idea that somehow there has to be direct evidence that he killed the children, and that somehow the circumstances of their murders do not matter. But and that's just flat wrong. When you look at the defendant is the one that described this event. So when you listen to his statement, he's the one that said, I killed my wife, and these are the circumstances that led up to it. And those circumstances were, I was pissed off. I went in there. I didn't care if she was going to get upset. Again, all of the stuff that had been going on all of these days, and he's mad at her because she will not make her co-worker tell his wife. And he's mad and he leaves. And he comes back in and he's angry. And you consider the circumstances and the continual inconsistencies in his statement. Saying one thing and then saying another. And it's not just from the 23rd to the 24th to the 25th to the 26th. A lot of times it's within the same statement. He'll say one thing and then say the other. And he can't keep his story straight. And when you consider the fact that there can be no question here that these children were murdered in a premeditated fashion. The defendant says that they were. He just says he didn't do it. He says he killed his wife, and Tyshawn took the children into the bathroom and beat them with an axe in the head. The children were killed in a premeditated fashion. The question is, who did it? And when you consider the circumstances of this case, who had the motive? And when you consider his story, which absolves himself of guilt of those murders and blames it on somebody else who had no motive, whose very presence in the house that night makes no sense, there's no evidence that supports the conclusion that he was ever there. His DNA was never found in the car, in the house. His fingerprints was never found in the car, in the house. All of the physical evidence, all the forensic evidence that connects this crime together, all of it is the defendant. Talia Otto's blood is found on his shoes. Talia Otto's blood is found on the trunk mat that he put in the dumpster. That piece of plastic that was used to cover the seat has his boot prints on it. When you consider all of those circumstances, and when you consider there's only two people that could have done this, and his story doesn't add up. He's given inconsistent accounts over and over and over again, and all the physical evidence points to him, and none of it points to Tyshawn Jackson at all. Of course the defendant is going to blame Tyshawn Jackson because his plan was to admit what he could not deny and to deny what he could not admit. He could not admit to the killing of those children. But he is the only one that it makes any sense. When you consider, when you apply your common sense to this case, the answer is he is the only one. He is the only one that could have committed this crime. And I trust that when you go back to that jury room and you consider all of the evidence, and you consider all of the inconsistencies, all of the lies, and all of the evidence that points not at Tyshawn Jackson, that points at him, that points at Luis Toledo, I am confident that your verdict will be guilty of first-degree murder of Talia Otto. I am confident that your verdict will be guilty of the first-degree murder of Michael Elijah Otto, and that your verdict will be guilty of second-degree murder as it relates to Yesenia Suarez, and guilty of tampering with physical evidence. Thank you.
Thank you.